La Cour.
Please be seated. Good morning. The sitting is now open. The court meets this morning to hear the following participants on the questions submitted by the General Assembly, namely the Maldives, Mexico, Namibia, and Norway. Each of the delegations has 30 minutes at its disposal for its presentation. The court will observe a short break after the presentation of Mexico. I shall now give the floor to His Excellency, Mr. Husham, speaking on behalf of the Maldives. Sir, you have the floor.
Mr. President, members of the court, I have the honor to appear before you on behalf of the Republic of Maldives. The issues before the court in these proceedings could not be of higher importance. They arise in a context of utmost desperation and suffering in the occupied Palestinian territory. The Maldives has long stood at the forefront of advocacy for the people of Palestine. Our position has never wavered, nor has our fight to realize for the Palestinians the right to self-determination, the right to dignity, and the right to life. The Maldives has consistently spoken out on the need to ensure the delivery of humanitarian assistance in the occupied Palestinian territory. UNRWA is the body widely recognized as the backbone and the beating heart of that assistance. The Maldives, like many other states, has expressed grave alarm at Israel's deliberate steps to dismantle this body. In its written statement, the Maldives has highlighted the numerous ways in which Israel has interfered with UNRWA's activities. These actions are not isolated incidents. They form part of a broader pattern of Israel disregarding international law. The Maldives has cast a spotlight on one of the many devastating concrete impacts of Israel's conduct by focusing on access to water in the occupied Palestinian territory. It has explained how each of these forms of conduct has entailed flagrant breaches of Israel's duties as an occupying power and as a member of the United Nations. These proceedings present a historic opportunity for the court to reaffirm Israel's obligations in relation to the delivery of humanitarian assistance and to ensure that international law produces tangible results for the Palestinian people whose lives depend on it. Today, the Maldives oral submissions will focus on two topics. First, Ms. Amy Sanders' submissions will respond to Israel's misplaced reliance on security concern and military necessity in an attempt to evade international legal obligations. Second, Dr. Naomi Hart will address the legal consequences of Israel's purported withdrawal from the agreement set out in the 1967 exchange of letters between Israel and UNRWA. To conclude my remarks, the Maldives stands unavered in its support of an independent and sovereign Palestinian state founded on the pre-1967 borders with East Jerusalem as its rightful capital. We will not falter in our advocacy for a permanent ceasefire and for the safe and dignified return of displaced Palestinians to their homes. The Palestinian people have an inalienable right to unhindered access to humanitarian assistance. The Maldives stands firm in its support for UNRWA and its ability to perform its indispensable mandate without unlawful interference. Our commitment is clear and unshakable. As recalled on Monday, the cause of Palestinians is one of justice, and we trust that this court's opinion will advance that just cause in accordance with international law. Mr. President, I thank you for your attention and ask that you give the floor to Ms. Sanders.
I thank Mr. Usham. I now invite Ms. Amy Sander to address the court. You have the floor, madam.
Mr. President, members of the court, it's an honor to appear before you on behalf of the Republic of Maldives. Partisan, one-sided, denying Israel's security and military needs. Those are the descriptors that are used to challenge the weight of submissions before you, which insist that Israel cannot evade its obligations by appeals to military expediency. Mindful of certain judges' recent reminder that questions before the court should be approached in a balanced manner, this morning the Maldives engages with this challenge directly. The overarching point is this: when assessing the relevance of Israel's security and military needs to its provision of humanitarian assistance to the civilian population of the occupied territories, this requires analysis of the particular rules to identify their precise contours and pinpoint how security needs are factored into the specific context at issue. As Judge Talade has observed, international law is not agnostic to security concerns, but the notion of security interest does not constitute an independent legal rule or optional add-on permitting a state to depart from fundamental rules of the system. My submission will focus on considering this overarching point with respect to Israel's obligations as an occupying power. The obligations of an occupying power have been specifically framed to apply in contexts of armed conflicts where security and military interests are necessarily heightened. Those interests are thus embedded in the formulation of the primary obligations, assessing precisely where the careful balance lies between military and humanitarian considerations requires precise analysis of the rules which are applicable to three core questions in these proceedings. The first core question: can Israel's security or military interests serve as a basis to refuse consent to UNRWA acting in the occupying territories to provide essential supplies? Israel has stated that it has a broad discretion to administer the occupied territory, but such a high-level assertion is of limited assistance, noting that in any event, this court has confirmed that administrative duty is to be exercised for the benefit of the local population. More instructive is to ask, what do the specific rules on relief in occupied territories say? If an occupying power is not itself providing essential supplies, such as water, it must agree to relief schemes. Article 59 of the Fourth Geneva Convention is clear on that. It's also clear that Israel, as the occupying power, retains in principle a discretion as to which state or impartial humanitarian organization provides the relief scheme, provided that there is more than one that can do so in practice. And it is not obliged to agree to relief from a humanitarian organization that is not impartial. And it's through that prism of impartiality that an occupying power's security or military interests may be accommodated within the carefully calibrated legal framework. The Maldives makes 6 points. First, the intended meaning of impartiality is to be informed by the Red Cross principles, which focus on who the organization offers aid to. It's impartial if it brings relief to the local population without any adverse distinction. Israel's written statement demonstrates that Israel's complaint, in fact, concerns an alleged lack of neutrality. Contrary to what was submitted yesterday, neutrality is, on its ordinary terms, a separate concept, requiring that the organization does not take sides in hostilities or engage in controversies of a political, racial, religious, or ideological nature. The Maldives accepts, however, that neutrality must also be relevant to the interpretation of Article 59, read in context. My second point is that lack of either impartiality or neutrality must be assessed objectively. The Maldives does not accept Israel's submission that it depends on what the occupying power perceives. That would be an unworkable standard open to abuse. Third, and relatedly, there must be sufficient evidence of that objective matter. That is consistent with the well-established interpretive principle of effectiveness and the obligation of good faith performance of a treaty obligation. It's also consistent with the position of several states in the negotiations of an article concerning relief in Additional Protocol 1, namely that refusal of such relief must not be for, I quote, arbitrary or capricious reasons. Here, Israel has had opportunities to share relevant evidence, but, as noted by the Secretary General, has chosen not to do so. My fourth point, even when individual humanitarian workers engage in conduct that violates principles of impartiality or neutrality, that does not necessarily mean that organization itself loses any claim to be impartial or neutral. Even taking Israel's case at its highest, of UNRWA's total personnel of some 30,000, it's less than 5% that Israel alleges in its written statement are not neutral. Further, the UN has found through 2 separate investigations that the evidence shows that Israel's allegations against UNRWA itself are unfounded, as highlighted by many participants this week. My fifth point, in circumstances where there is only one impartial humanitarian organization that can, in practice, provide the essential supplies, the occupying power's discretion is necessarily limited. Yesterday, it was submitted that the court should not address certain factual issues. Sufficiency of information is for the court's assessment. And on the factual question of whether UNRWA plays a unique role in delivering humanitarian assistance to Palestinians, there's an abundance of evidence. Finally and critically, the occupying power's discretion to refuse a relief scheme is limited by its overriding duty to ensure population needs are in fact met. Is Israel fulfilling this duty? The reality on the ground, which Israel insists should be the focus, demonstrates that it is not. This is reflected in the horrifying information collated by the Maldives with respect to water supplies across the occupied territories. And indeed, as recalled earlier this week, Israel's own Prime Minister stated that as of the 2nd of March, I quote, the entry of all goods and supplies to the Gaza Strip will be halted. Turning now to the second of my 3 core questions, can Israel's security or military interests serve as a basis to restrict, disrupt, or otherwise impede the activities of UNRWA in providing essential supplies in the occupied territories? Reflecting the careful balancing of interests only in prescribed circumstances which do not apply here. The Maldives refers to 3 provisions of the 4th Geneva Convention addressing occupied territories. First, Article 63 provides that measures may be imposed with respect to the activities of a relief society, but the reasons for the measure must be an urgent one of security. The measures can only be temporary and exceptional, and there's an implicit requirement of proportionality between the security objective and the measure taken. A contrario, an occupying power cannot rely upon reasons of security to justify the general suspension of all humanitarian activities in an occupied territory, or, as in this case, to implement legislation which has as its objective or effect the permanent dismantling of UNRWA. The second provision is the fourth paragraph of Article 59, addressing a right to search consignments and regulate their passage. On its plain terms, this right does not apply to an occupying power. In any event, that right, whilst potentially informed by security concerns, must be exercised in a proportionate and targeted manner. Specifically, it cannot undermine the very purpose of Article 59, which is to ensure the population is adequately supplied, or the occupying power's separate obligation to facilitate rapid distribution of consignments pursuant to Article 61. The third provision is Article 60, and this provides that it is only in cases of urgent necessity and in the interests of the population of the occupied territory that the occupying power may divert relief consignments from the purpose for which they were intended. So, it's a power of diversion, not cessation, and while security interests could be relevant, the interests of the population remain paramount. The third core question: can Israel's security or military interests serve as a basis to restrict UNRWA personnel from contributing to the provision of essential supplies? The basis for asserting that they can is Article 71 of Additional Protocol 1. Assuming Article 71 applies to Israel as customary international law, the Maldives makes 4 points. First, approval of personnel must be subject to the overriding obligation of the occupying power to ensure the relevant supplies for the civilian population and facilitate relief schemes. Second, while subparagraph 3 does envisage measures impacting the activities of personnel, measures are restricted to limiting, not eliminating the personnel's activities, or temporarily restricting their movements. Third, that power can only be exercised in one circumstance: imperative military necessity, which has not been demonstrated here. Fourth, the power may be exercised with respect to specific personnel, but not the organization itself, a view supported by the context. Subparagraph 4 provides that the mission of any of the personnel, i.e. specific persons, may be terminated if that person fails to take into account relevant security requirements. Mr. President, members of the court, the Maldives is alive to the quest for balance on these sensitive topics. By engaging in good faith with the arguments of Israel, pulling in the opposite direction to that of the Maldives, and by seeking to unravel the knot between them by precise reference to the applicable rules, the Maldives hopes to contribute to that quest. I now ask that you call Dr. Hart to the podium to conclude the Maldives submissions.
I thank Ms. Sander. I now give the floor to Dr. Naomi Hart.
Mr. President, members of the court, on the 28th of October 2024, the Israeli Knesset passed a law stating that the invitation for UNRWA to operate in Israel's territory, as set out in the 1967 exchange of letters, was to expire imminently. Days later, Israel wrote to the President of the General Assembly stating that it withdraws its request to UNRWA. By these actions, Israel purported to use its term, abrogate the provisional agreement reached in the exchange of letters. Today, it is an honour to address, on behalf of the Republic of Maldives, the legal consequences of Israel's purported withdrawal from the exchange of letters as regards its obligations to confer immunities and privileges on UNRWA and its personnel. I will focus on two questions. First, what are the consequences of this purported withdrawal on Israel's obligations under the UN Charter and the General Convention? Second, what are the consequences for Israel's obligations under the exchange of letters itself? I turn to the first question. The fundamental point already highlighted by the Maldives and the overwhelming majority of other participating states is that Israel's obligations under the Charter and the General Convention exist independently of any agreement reflected in the exchange of letters, and thus survive any purported termination of that agreement. Starting with the UN Charter, Article 105.1 confers on the UN, including subsidiary organs such as UNRWA, an entitlement to privileges and immunities necessary for the fulfilment of the UN's purposes. Under Article 105.2, UN officials similarly enjoy such privileges and immunities as are necessary for the independent exercise of their functions. Those entitlements are not conditional on any other agreement being reached. Further, they cannot be narrowed by any other agreement, given that Article 103 provides for the Charter's supremacy over any other conflicting international agreement. The General Convention is a treaty contemplated by Article 105.3 of the Charter in that it determines the details of the application of Article 105, but of course it does so without attenuating any Charter obligations. The obligations owed under the General Convention are integral to membership of the UN. This is clear from the Convention's preamble, which refers to Article 105, as well as Section 31, which envisages that all member states shall accede to the Convention. Section 35 provides that a state shall remain bound by the Convention for so long as that member remains a member of the United Nations. Section 36 sets out confined circumstances in which supplementary agreements may adjust the provisions of the Convention for individual member states if entered into by the UN Secretary-General and approved by the General Assembly. Let us turn then to the exchange of letters. As I will show, the irresistible conclusion is that nothing in the exchange was intended to, or did in fact, replace, derogate from, or adjust the terms of the General Convention or the UN Charter. As a starting point, the exchange of letters is not between the UN Secretary-General and Israel. This is not a supplementary agreement under Section 36 of the General Convention. Within the exchange, the letter from Michael Comey, Israel's then permanent representative to the UN, confirms the agreement that UNRWA would continue its assistance to the Palestine refugees. Indeed, UNRWA had by then been operating in the occupied Palestinian territory for many years, during which time there is no doubt that it and its personnel enjoyed the privileges and immunities conferred by the UN Charter and the General Convention. At paragraph G, Mr. Comey's letter states that Israel will recognise that the General Convention, to which Israel is a party, shall govern the relations between the government of Israel and UNRWA in all that concerns UNRWA's functions. This was a straightforward affirmation of the obligations by which Israel was already and remained bound. Other paragraphs within Mr. Comey's letter provide more granular details of the agreement concerning UNRWA's treatment of UNRWA. Some of these details closely mirror the terms of the General Convention, which are thus duties independently owed under that convention. For example, paragraph A states that Israel will ensure the protection and security of the personnel, installation and property of UNRWA, reflecting the Convention's inviolability provisions. Other paragraphs, such as paragraph E, concerning provisions for radio, telecommunications and landing facilities, arguably do not have such direct analogues in the General Convention. However, the letter in response to Mr. Comey from UNRWA's Secretary-General states, the facilities enumerated in paragraphs A to G of your letter are essential if the agency is to operate effectively. I reiterate that, pursuant to Article 1051 of the Charter, Israel is obliged to accord UNRWA all privileges and immunities that are necessary for the fulfilment of its purposes. Thus, Israel was bound to accord these privileges and immunities independently of the exchange of letters. Mr. Comey's letter states that Israel will facilitate the task of UNRWA to the best of its ability, subject only to regulations or arrangements which may be necessitated by considerations of military security. The court will recall that considerations of military expediency do not allow a state to deny a UN body the privileges and immunities to which it is entitled under the Charter and the General Convention. As no supplementary agreement has adjusted Israel's obligations under the General Convention, and no other agreement is permitted to conflict with the UN Charter by virtue of Article 103, the exchange of letters cannot be taken as having introduced any caveat to Israel's obligations under those instruments, including an entitlement to depart from those obligations on security grounds. The bottom line is this: an instrument such as the exchange of letters may play a valuable function in affirming and particularising parties' understanding of their rights and obligations regarding privileges and immunities. However, such an instrument is not constitutive of those rights and obligations, which are instead rooted in other treaties to which a state must remain a party for as long as it is a member of the UN. It follows that even if Israel were able to withdraw from the exchange of letters, that would not affect its underlying and independent treaty obligations to accord privileges and immunities to UNRWA and its personnel. That leads me to my second topic. What are the consequences of that same purported termination for Israel's obligations under the exchange of letters itself? The exchange of letters was intended to be a legally binding agreement. This is clear from the use of terminology denoting legal obligation, such as confirming our agreement, as well as indicia such as the provision that the rights and obligations would remain in force until replaced or cancelled. It has also been published in the UN Treaty Series. As for the use of the word provisional, it is clear from context that all that word indicated was that the agreement could ultimately be replaced or cancelled. Crucially, those words, replaced or cancelled, do not confer a right of unilateral denunciation. This agreement is thus within the scope of the international law rule set out in Article 56 of the 1986 Vienna Convention on the Law of Treaties. Either party can denounce the treaty only if it is established that, at the time the treaty was concluded, the parties intended to admit the possibility of denunciation, or a right of denunciation may be implied by the nature of the treaty. 2 points arise from this. First, it may be tempting to draw an analogy between this exchange of letters and the headquarters agreement between the World Health Organization and Egypt, considered by the court in its 1980 advisory opinion. There, the court held that, given the nature of that agreement, Egypt was entitled to bring it to an end unilaterally. However, The exchange of letters is not of the same nature. First, and fundamentally, it is not an agreement concerning UNRWA being headquartered in Israel. Instead, it concerns the operation of a humanitarian relief agency in territory over which Israel is occupying power, but not sovereign. Second, as occupying power, Israel is obliged to ensure the availability of humanitarian supplies and to allow relief societies to pursue their humanitarian activities, as addressed by Ms. Sander. Third, UNRWA was acting in the occupied Palestinian territory pursuant to a General Assembly mandate. In light of those factors, contrary to Israel's submissions, this agreement was not one that either party could abrogate at will, and nor is it of a nature that would allow this. In the absence of UNRWA's agreement, Israel's purported denunciation of the exchange of letters is of no legal effect. Second, even if Israel could denounce the agreement in the exchange of letters, it would be required at a minimum to provide a reasonable period of notice and to engage in prior good faith consultations and negotiations with UNRWA with a view to causing the minimum possible prejudice to UNRWA's work. Israel has complied with none of these requirements. Mr. President, members of the court, that concludes the submissions of the Maldives.
I thank the representatives of the Maldives for their presentation. I now invite the next participating delegation, Mexico, to address the court, and I call upon Her Excellency, Ambassador Carmen Moreno, to take the floor.
Mr. President, Madam Vice President, distinguished members of the court, my name is Carmen Moreno Toscano, Ambassador of Mexico to the Kingdom of Netherlands. It is a great honor for me to appeal before the International Court of Justice on behalf of the United Mexican States and to participate in these oral proceedings concerning the obligations of Israel in relation to the presence and activities of the United Nations, other international organizations, and third states, and in relation to the occupied Palestinian territory. Allow me to express Mexico's deepest respect for the essential role that this court plays as the principal judicial organ of the United Nations, and for the opportunity afforded to states and organizations to contribute to its deliberations in this urgent matter. Mexico asserts that this court has jurisdiction to render the requested advisory opinion, as all the requirements outlined in Mexico's written statement have been satisfied. Mexico is aware that certain states have urged the court to decline to render an opinion. However, the advisory function of this court is not contentious in nature and exists precisely to assist the United Nations in clarifying complex legal questions. The present request does not adjudicate Israel conduct but seeks legal guidance on the scope of its obligations under international law. As this court has previously affirmed, advisory opinions serve to provide legal clarity to the organs of the United Nations and assist them in the fulfillment of their mandates. Mexico highlights the court's advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, where it confirmed the relevance of its opinion for the General Assembly. In this context, the significance of this procedure is all the greater in light of the urgent humanitarian crisis unfolding in the state of Palestine and the growing restrictions affecting the presence and activities of international actors engaged in relief and protection efforts. With this in mind, and with the permission of the court, the statement of Mexico will be delivered as follows. First, the relevant facts considered by Mexico. Second, Mexico's position on the obligations of Israel as a member of the United Nations and under the law of privileges and immunities. Third, Mexico's position on the obligations of Israel under international humanitarian law and international human rights law. Fourth, our concluding remarks. Mexico's intention is to support the court in this task, reaffirming our unwavering commitment to the rule of law, the principles of the United Nations Charter, and the promotion and protection of international humanitarian and human rights law. With the permission of this honorable court, I ask you, Mr. President, to invite Ms. Patricia Perez to present the relevant facts considered by Mexico.
I thank Ambassador Moreno. I now invite Ms. Patricia Perez to address the court. You have the floor, madam.
Mr. President, distinguished members of the court, it is a privilege to stand before you to adequately address the legal issues raised in the request submitted by the General Assembly. It is essential to briefly recall the circumstances that have prompted this proceeding. Just 2 days ago, the UN Secretary General Antonio Guterres told the Security Council that the humanitarian situation throughout the Gaza Strip has gone from bad to worse to beyond imagination. Since 7 October 2023, following the escalation of the hostilities between Hamas and Israel, the civilian population of Gaza has endured severe suffering due to repeated bombardments, mass displacement, and the almost total collapse of essential infrastructure. Particularly concerning has been the situation faced by the United Nations Relief and Work Agency for Palestine refugees in the Near East. As the principal provider of basic services to Palestine refugees in Gaza and the West Bank, UNRWA's role is unique and irreplaceable. Yet, in January 2024, following allegations made by the Israel authorities against certain UNRWA personnel, a number of states suspended their funding to the agency, seriously undermining its operational capacity. Moreover, Israel has moved forward with legal and administrative measures to obstruct UNRWA's operation. Other international organizations and third states seeking to provide humanitarian assistance in Gaza have been similarly impeded. Mexico expresses its deep concern over the breakdown of the ceasefire in Gaza, which has further limited the entry of vital supplies. The unilateral decision to resume hostilities has resulted in a devastating setback for humanitarian relief efforts and exacerbated the already dire conditions. This concern is shared by the independent United Nations human rights experts, who describe Israel's decision as something that reopened, and I quote, the gates of hell. Since last March, Israeli authorities have halted the entry of all life-saving supplies, including food, medicine, fuel, and cooking gas for 2.1 million people. Israel has also cut power to southern Gaza's desalination plant, limiting access to clean water for 600,000 people. Additionally, Israeli military operations in the northern West Bank have displaced 40,000 Palestinians. Mexico also draws this court's attention to the Security Council meeting of last 3 April, where the United Nations High Commissioner for Human Rights stated that the war on Gaza has seen the greatest number of aid workers killed in any conflict. He particularly pointed out the recent uncovered mass grave, where 15 first responders, including 8 Palestine Red
Crescent Society paramedics, 6 civil defense members, and 1 UN officer were buried, including their vehicles, in an outrageous effort to cover this act. They were killed in an unprovoked and heinous attack while on mission to save lives. The gravity of this situation deepens with every passing day, even as we speak. These facts illustrate the extent to which the humanitarian situation in the state of Palestine continues to deteriorate, despite repeated calls from the international community for restraint, access, and protection. They also reinforce the legal and moral urgency of the question before this court, particularly in view of Israel's obligations under international law. With the permission of the court, I ask you, Mr. President, to give the floor to Mr. Pablo Arrocha, legal advisor of the Mexican Ministry of Foreign Affairs, to present Mexico's considerations regarding the obligation of Israel under international law and our concluding remarks. Thank you.
I thank Ms. Perez. I now give the floor to Mr. Pablo Arrocha.
May it please the court. Mr. President, Your Excellencies, it is a great honor to stand again before this court, albeit under these dramatic circumstances. The advisory opinion to be rendered is essential to reasserting the fundamental principles of international law, particularly in situations of occupation. The ability of the United Nations and its organs to carry out their work depends largely on the respect for privileges and immunities granted under international law, including to its personnel, and on the cooperation of all member states. These principles are not optional. They are binding obligations that derive from the UN Charter and from the Convention on the Privileges and Immunities of the United Nations, to which Israel is a party. Under Article 105, Paragraph 1 of the UN Charter, the United Nations enjoys in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purposes. These are further specified in the 1946 General Convention on the Privileges and Immunities of the United Nations, whose Article 2 provides for the inviolability of UN premises, archives, and communications, and the immunity of its property and assets from any form of interference. As a member of the UN, Israel is bound by these provisions, including those concerning the respect and protection of its agencies. Any measure that obstructs the work of UNRWA or other UN entities, such as denial of access, attacks on its personnel, facilities, or legislative restrictions, contravenes these legal obligations and undermines the purposes and principles of the organization. Some written statements in these proceedings appear to suggest that cooperation with the United Nations agencies, such as UNRWA, can be suspended at will by the occupying state. Mexico submits that such interpretations are inconsistent with the UN Charter and with the Convention on the Privileges and Immunities of the United Nations, which provide legal safeguards for the independent functioning of the organization, and which cannot be unilaterally suspended, as there is no provision allowing for it. Moreover, Article 2, Paragraph 5 of the Charter provides that all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. Israel is also bound by Articles 55 and 56 of the Charter, which establish the duty of international cooperation in promoting respect for human rights, the principle of self-determination, and improving living conditions. These provisions commit all member states to work individually and collectively to advance the dignity and well-being of peoples, especially those living under occupation or in humanitarian crisis. General Assembly Resolution 79/141 explicitly calls for the facilitation of aid and protection to the Palestinian people, specifically the necessity of international assistance to alleviate economic and social hardships in the occupied Palestinian territory. Israel is also subject to obligations arising from the judicial decisions of this court, and Article 41 of the court statute and its jurisprudence confirms the binding nature of its provisional measures. In its orders of 26 January, 28 March, and 24 May 2024, issued in the South Africa versus Israel case, the court instructed Israel to take all necessary steps to facilitate humanitarian assistance and to refrain from actions that obstruct such aid. These orders must be fully respected. Mexico asks the court to confirm and reaffirm that all UN member states, including Israel, are legally bound to uphold the privileges and immunities of the United Nations and its agencies, to facilitate international cooperation, and to abstain from any measures that hinder the delivery of humanitarian assistance in territories under occupation. Mr. President, Excellencies, I now turn to the obligations that arise from Israel's continuing presence as an occupying power in the state of Palestine, obligations rooted in international humanitarian law and international human rights law. Mexico takes note that certain submissions have questioned the applicability of the law of occupation to parts of the state of Palestine. However, as this court reaffirmed in its 2004 and 2024 advisory opinions, Israel acts as and is an occupying power. This is not determined by formal declarations or political arrangements, but by its presence and effective control exercised as a foreign power in the territory of the state of Palestine. This court has previously confirmed the applicability of international human rights law and international humanitarian law in situations of occupation, including in the specific context of the occupied Palestinian territory, where these regimes are complementary and concurrently applicable. Under international humanitarian law, the legal status of Israel as an occupying power is well established. It was also very clearly said by Judges Shue, Brandt, Gomez Robledo, and Tladi in their joint declaration to the court's order of 28 March 2024. I quote, "Israel is the occupying power in the Gaza Strip. It controls Gaza's land border and all its land crossing access, as well as its air and maritime areas. Israel's dominant control over Gaza explains why Israel has the primary responsibility to ensure unhindered and unimpeded access, in particular, the land crossing access for the delivery of humanitarian assistance to the Palestinians in Gaza," end of quote. To make things worse, such occupation has extended over time, infringing its essentially temporary character and turning it into a permanent one. As it has been pleaded by the delegation of the State of Palestine before this court, permanent occupation is a legal oxymoron. Even the court stated in its advisory opinion of 19 July 2024 that the policies and practices that Israel has implemented in the occupied territory manifest an intention to create a permanent and irreversible Israeli presence in the occupied Palestinian territory, which amounts to annexation and makes its continued presence unlawful. The fact that an occupation is prolonged does not in itself change its legal status under IHL. The occupying power retains its basic duty to administer the territory for the benefit of the local population. This court has considered that to conclude otherwise would be contrary to the object and purpose of the Fourth Geneva Convention and would deprive the population subject to an ongoing occupation of the protection that it enjoys under international law. As the UN Secretary General has said, even war has rules. Yes, war has rules and war has limits. IHL sets out those limits, which seek to preserve humanity, even under the most violent circumstances of war. As an occupying power, Israel is bound by the Fourth Geneva Convention of 1949, particularly Articles 55, 56, and 59, which impose clear obligations to ensure to the fullest extent of the means available to it the provision of food, medical supplies, establishments and services, and humanitarian relief, respectively. The court has already unanimously ordered Israel to take all necessary and effective measures to ensure, without delay, in full cooperation with the United Nations, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance, including food, water, electricity, fuel, shelter, clothing, hygiene and sanitation requirements, as well as medical supplies and medical care to Palestinians throughout Gaza, including by increasing the capacity and number of land crossing points and to maintaining them open for as long as necessary. Israel must abide by these obligations and refrain from actions such as taking over the key southern Gaza corridor, which it did last 12 April, separating Rafah from the rest of the Gaza Strip, giving residents fewer options to seek shelter. This is not a theoretical or distant crisis. It is unfolding in real time with consequences that the law cannot ignore. Already a year ago, the World Food Programme alerted that 70% of the population in Gaza was suffering from catastrophic levels of hunger. As of 10 March 2024, 1.1 million people in Gaza, that is 300,000 more people than the estimated victims in the Rwandan genocide, had completely exhausted their food supplies and coping capacities and were struggling with catastrophic hunger and starvation. This prompted the former head of OCHA, Martin Griffiths, to say that, and I quote, "The international community should hang its head in shame for failing to stopping it," end of quote. This horrific situation has not gotten any better. On 8 April 2025, the Secretary General indicated, and I quote, "More than an entire month has passed without a drop of aid into Gaza. No food, no fuel, no medicine, no commercial supplies. Gaza is a killing field and civilians are in an endless death loop," end quote. And just last week, on 25 April, the WFP indicated, and I quote again, that it has run out of food in the Gaza Strip as Israel continues to block the entry of all humanitarian aid into the enclave. The situation inside the Gaza Strip has once again reached a breaking point. People are running out of ways to cope, and the fragile gains made during the short ceasefire have unraveled. Without urgent action to open borders for aid and trade to enter, WFP's critical assistance may be forced to end, end of quote. Simply put, starvation is being used as a method of warfare. The use of starvation of the civilian population as a method of war is prohibited under customary international law, both for international and non-international armed conflicts. The Rome Statute of the International Criminal Court criminalizes this conduct in both types of conflicts, indicating that intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival, including willfully impeding relief supplies, is a war crime. The ICC has already issued arrest warrants on this account. Excellencies, starvation is starvation is starvation, and there is no justification whatsoever for it. It is in this context that the recent measures by Israel, including the restriction of access to humanitarian aid, the obstruction of fuel and medical supplies, and the systematic targeting of infrastructure critical to civilian survival, must be assessed. Such actions constitute collective punishment and reprisals against the civilian population, which are also prohibited under IHL. Excellencies, Mexico reaffirms the dual applicability of IHL and human rights law in situations of occupation, which is central in the present advisory proceedings. Israel is bound to uphold international human rights law in the occupied Palestinian territory as a state party to the International Convention on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Rights of the Child, the International Convention on the Elimination of All Forms of Racial Discrimination, the International Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, and the Convention on the Elimination of All Forms of Discrimination Against Women. This court has asserted that international human rights instruments are applicable in respect of acts done by a state in the exercise of its jurisdiction outside of its own territory, particularly in occupied territories. Article 27 of the Fourth Geneva Convention states inter alia that protected persons shall at all times be humanely treated. Articles 2 and 26 of the ICCPR, Article 2, Paragraph 2 of the ICESCR, and Article 1 of the CERD prohibit discrimination in the exercise of rights. Practices that restrict Palestinian access to aid, healthcare, water, and freedom of movement, which do not apply to Israeli settlements, amount to discriminatory treatment.
Excuse me to interrupt. Please slow down for the interpreters. Thank you very much.
Will do, Mr. President. Thank you. And I apologize to the interpreters. Furthermore, under CAT and customary international law, the deliberate denial of food and essential services may constitute inhuman treatment or torture, particularly when it affects vulnerable groups such as children. Moreover, in accordance with the CRC, states must ensure children's access to healthcare, education, and adequate nutrition, while taking all appropriate measures to protect them from harm. Likewise, under CEDAW, Israel is obligated to prevent gender-based violence and guarantee that women have access to essential resources. Consequently, Israel must ensure the enjoyment of the right to life, the prohibition of torture and inhuman or degrading treatment, the right to food, health, water, and education, and the rights of children and women without discrimination for all persons living in the occupied Palestinian territory. The court should clarify the scope of these obligations as they relate to the activities of the UN and other actors in the occupied Palestinian territory. And by doing so, it will strengthen the legal framework for the protection of civilians and contribute to the restoration of respect for the rule of law in one of the world's most protracted and severe humanitarian crises. Mr. President, distinguished members of the court, allow me to conclude with the following remarks. The Hamas attack of 7 October 2023, which took the life of around 1,200 innocent people, and from which there are still hostages in captivity, was a heinous act of terror that we condemn. However, legally and morally, the reality that has been unfolding before our eyes in Gaza cannot and must not be justified. As it has been said by the UN Secretary General, nothing can justify the collective punishment of the Palestinian people. UNRWA Commissioner General Philippe Lazzarini, on 14 March last year, said that more children have been killed in Gaza in recent months than in 4 years of conflict worldwide, with at least 12,300 children who have died, compared with 12,193 globally between 2019 and 2022. According to the latest UNRWA situation update in Gaza, valid as of last 22 April, since 7 October 2023, at least 51,266 Palestinians have been reportedly killed, with many more unaccounted for, and with about 70% of those killed being women and children. 916 Palestinians have been reportedly killed also in the West Bank, including East Jerusalem. And over 290 UNRWA staff have been killed. According to the UN, at least 1.9 million people, about 90% of the population across the Gaza Strip, have been repeatedly displaced during the war, over 10 times or more. The necessity and urgency to stop this tragedy, which has been categorized as genocide by the Special Rapporteur on the Situation of Human Rights in the Palestinian territory occupied since 1967, Francesca Albanese, prompted the General Assembly to turn to the court. Right now, humanitarian corridors are closing, children have no food, lives are being lost. The legal obligations and rules of law under consideration of the court in these proceedings are not abstract principles. The reality and the lives of millions of individuals depend on their effective implementation. The humanitarian catastrophe that all of us are witnessing is a deliberate choice, consequence of a political decision, and it is therefore avoidable and reversible. It requires Israel first, as a member of the United Nations, to respect the principles of the Charter, including the duty to cooperate with the organization and to uphold the legal protections afforded to its institutions and personnel. Second, in its capacity as an occupying power, to comply with the rules of IHL, including those concerning the protection of civilians and the facilitation of humanitarian relief. This includes the duty to allow and facilitate without impediment the activities of the United Nations, international agencies, and third states that provide vital assistance to the population under occupation. And third, to comply with its obligations under international human rights law, including the obligation to ensure the enjoyment of fundamental rights without discrimination and to prevent inhuman or degrading treatment, including that which results from the denial of basic necessities. However, as it has constantly been repeated by so many voices, from the Secretary General to members of this honorable court in a joint declaration, the basic premise to achieve all this is that Israel must suspend its military operations immediately. In the meantime, Israeli authorities must ensure complete and unfettered access for humanitarian goods throughout Gaza. No ifs, no buts. This is a pivotal moment, not only for the protection of the role of the United Nations and of international law. The preservation of our shared humanity is on the line. The world should not and cannot normalize the dehumanization of an entire people. No conflict can come at the cost of human dignity. We trust and we hope that the court will agree with us to uphold this premise for all our sakes. Thank you very much.
I thank the representatives of Mexico for their presentation. Before I invite the next delegation to take the floor, the court will observe a break of 15 minutes. The hearing is suspended. Please be seated. The sitting is resumed. I now invite the next participating delegation, Namibia, to address the court, and I call Her Excellency Dr. Mekonjo Kapanda Yunus to the podium. You have the floor, Madam.
Mr. President, distinguished members of the court, it is my distinct honor to appear before you on behalf of the Republic of Namibia in these proceedings. Namibia co-sponsored the resolution of the General Assembly requesting this advisory opinion. It is, in fact, a mark of our commitment that we are now participating for the third time in advisory proceedings on the question of Palestine. Mr. President, in history, when confronted with moments of horror, we, members of the international community, have always faced a stark choice. We can look the other way and do nothing. We can abandon the institutions that we have built, and we can gloss over the indefensible. That, however, is not the path that has led us here. Even before the end of the Second World War, in the face of the suffering of the victims of war, including the Jewish people, 44 governments chose to establish an international agency for the provision of food, fuel, clothing and shelter, and other basic necessities. After the war, instead of abandoning global institutions, states chose to rebuild and create a new organization, the United Nations, including this court as its principal judicial organ. And instead of abandoning universal norms, like the laws of war, states chose to adopt not only the Geneva Conventions, but also the Genocide Convention, the Universal Declaration of Human Rights, among many others. That is the path that led us here. Namibia knows that this path is not an easy one. The international community brought multiple proceedings before this court on the question of Southwest Africa, culminating in the court's 1971 opinion. In the face of that opinion, the apartheid regime of South Africa refused to end its unlawful occupation of Namibia and to permit the presence and activities of the UN Council for Namibia in our territory. The parallels are clear. Nevertheless, the international community persisted in their solidarity, and after a long and arduous struggle, the Namibian people prevailed in 1990. As our late president, Dr. Hague often said, Namibia is a child of international solidarity, midwifed by the United Nations. As a member of the international community and as a historical beneficiary of international solidarity, we have the moral duty to seek this advisory opinion. And by doing so, we aim not to damage, but rather to defend the international legal order and the value of multilateralism in promoting international peace and security. The humanitarian catastrophe unfolding in the occupied Palestinian territory should compel all of us to uphold and protect the integrity of our international institutions and universal norms. Mr. President, in our submissions today, Namibia will focus on the court's jurisdiction in these proceedings, Israel's obligations as a member of the United Nations, Israel's obligations arising from the Palestinian people's right to self-determination, and Israel's other obligations as the occupying power. Namibia will focus on UNRWA, given its indispensable role in providing essential humanitarian and development assistance to millions of Palestinians in the OPT, and given the specific measures adopted by Israel targeting its operations. However, Namibia notes that much of its analysis also applies in relation to the presence and activities of other international actors in relation to the OPT. Namibia respectfully disagrees with submissions made before this court that these proceedings are aimed at depriving Israel of its sovereign right to defend itself. Namibia further maintains that these proceedings in no way, and I quote, compromise the court's judicial integrity, nor do they make the law indistinguishable from politics. Mr. President, members of the court, I thank you for your attention and respectfully ask that you invite Professor Okoa to address the court.
I thank Dr. Kapanda Girunas. I now invite Professor Phoebe Okoa to address the court.
Mr. President, members of the court, it's both an honor and a special responsibility to appear before you on behalf of the Republic of Namibia. At the outset, Namibia wishes to respond very briefly to the argument, both explicitly and implicitly made, that the court should decline to render an advisory opinion in these proceedings, either because the matter is sub judice in the pending case between South Africa and Israel, or because of the court's previous advisory opinions on the question of Palestine. First, Namibia respectfully rejects the sub judice argument. These proceedings are fundamentally different from South Africa against Israel. They are different in character, they serve different purposes, and they engage different participants, and they concern different subject matters. South Africa against Israel concerns a specific question arising under a circumscribed basis of jurisdiction in the Genocide Convention. In the present proceedings, the court is not called upon to make any determination on the issue of genocide. Rather, the question posed by the General Assembly concerns Israel's obligations in relation to the presence and activities of other international actors in and in relation to the OPT. Moreover, there is no basis in the court's jurisprudence for the claim that because these proceedings touch upon issues relevant to South Africa against Israel, the court should refuse to provide assistance to the General Assembly in the discharge of its functions. Just as the initiation of proceedings by South Africa in December 2023 did not prevent the court from discharging its advisory function in 2024, their continuation now should not prevent the court from responding to the General Assembly's present request. Second, the question is not one which the court has been called to address in earlier advisory opinions. The question of Palestine is the longest-lived problem on the agenda of the United Nations and of this court. Yet on each occasion, the court has addressed the issue presented in light of the terms of the request and of the specific instruments relied on, recognizing the permanent responsibility of the United Nations for the Palestinian question. One of the first advisory opinions rendered by this court, the reparation for injuries case, concerned the capacity of the United Nations to bring a claim against Israel in relation to the death of Count Bernadotte, who was killed in the service of the United Nations. The court has subsequently given two advisory opinions in relation to the legal consequences of Israel's practices and policies in the OPT, thereby addressing the questions arising on their own terms and in light of specific instruments. However, this is the first time that the court is asked to determine the legality of specific measures and practices directed at UNRWA and other international organizations in the OPT. The request is not a repetition of what the court has already done. Therefore, Israel cannot plausibly object to the court giving advice to the General Assembly in relation to the functions and operations of its own subsidiary organ. In short, there are no compelling reasons for the court to decline the request. Mr. President, I now turn to Israel's obligations as a member of the United Nations regarding the presence and activities of UNRWA in and in relation to the OPT. Here, Namibia makes two specific submissions. First, Israel must assist and cooperate with the UN. And second, Israel must respect the UN's privileges and immunities. Namibia submits that Israel's membership of the United Nations entails an obligation to provide every assistance to and cooperate with the UN in good faith. This is both a cardinal and a constitutive principle under the Charter. First, Article 2.5 obliges Israel to give the UN every assistance in any action it takes in accordance with the Charter. Second, under Article 56 of the Charter, Israel has pledged to take action in cooperation with the UN to achieve the organization's purposes of promoting universal respect for human rights, economic and social development, and provide solutions to economic and social problems. Third, under Article 2.2 of the Charter, Israel must perform all of its obligations in good faith. The obligation of Israel to cooperate with the UN in good faith also exists under general international law. In this respect, UNRWA is the primary vehicle through which the UN has sought and is seeking to achieve these aims. Its mandate has been repeatedly renewed by the General Assembly, and it remains indispensable in providing critical assistance and humanitarian aid to the Palestinian people. Israel, however, argues that it does not have an obligation to assist or cooperate with UNRWA. First, Israel proposes that Article 2.5 is not applicable because it is limited to enforcement action taken by the UN Security Council under Chapter 7 of the Charter. This reading of the provision is contrary to its ordinary meaning as interpreted in accordance with Article 31 of the Vienna Convention on the Law of Treaties. The word "any action" in the first clause does not admit the additional restriction Israel asserts. This is in stark contrast with the second clause of Article 2.5, which specifically prohibits assistance to any state which the United Nations is taking preventive or enforcement action. The omission of the qualifier preventive or enforcement in the first clause cannot be an oversight and is crucial to the proper interpretation of Article 2.5. In other words, the obligation of members to assist the United Nations applies as a default. On the other hand, their freedom to assist other states is exceptionally restricted in order to achieve the objectives of preventive or enforcement action under Chapter 7. Moreover, as others have already demonstrated, Israel's interpretation finds no support in the practice of the organization or of its members. In this regard, as the court held in the 1996 WHO Nuclear Weapons Advisory Opinion, in interpreting a treaty that is the constituent instrument of an international organization, the organization's own practice may deserve special attention. This is especially so where the UN practice is generally accepted by states as it is here. In sum, Israel is bound to provide every assistance to achieve the objectives of UNRWA as a subsidiary organ of the General Assembly and of the United Nations. Second, Israel also argues that assistance under Article 2.5 is not required because the UN's action was not in accordance with, but manifestly contrary to the Charter and to the detriment of a member's vital interests. Israel also argues that the obligations under Articles 2.2 and 56 do not apply in exceptional and extraordinary circumstances such as this. These arguments are misplaced. Israel wrongly assumes that it has the unilateral power to disregard its fundamental obligations under the Charter based on a subjective evaluation of vital interests. Moreover, if Israel had wished to challenge the mandate of UNRWA, it could have done so through the many avenues of dialogue in the UN system. In sum, Namibia reiterates that Israel's actions, and particularly its anti-UNRWA laws and related conduct, violate its obligations under the Charter. The conduct entails a blatant refusal to cooperate with the UN, to facilitate UNRWA's work, and to respect its lawfully established mandate. Mr. President, this brings me to my second point, namely Israel's obligations to respect the UN's immunities and inviolability and Article 105(1) of the Charter and the 1946 General Convention. Namibia highlights two aspects of Israel's obligations in this regard. That is, their territorial scope and the absolute character of these obligations. First, Namibia emphasizes that Israel is obligated to respect the UN's inviolability and immunities in both Israel and as an occupying power exercising effective control in the OPT, including East Jerusalem. This is plainly necessary for the fulfillment of the organization's purposes and coheres with the UN's consistent practice, as other participants have highlighted. Indeed, Article 2, Sections 2 to 4 of the General Convention expressly refers to the immunity and inviolability of the UN wherever located. Second, Israel has again invoked the extraordinary circumstances of its security concerns to seek to justify conduct. In fact, according to Israel, it was UNRWA's refusal to respect Israel's withdrawal of cooperation that constitutes an abuse of the UN's privileges and immunities. Namibia submits that Israel's obligations to respect UN immunities and inviolability are absolute. This means, first, that the obligations are unqualified. They are not subject to exception or limitation. This much is evident on the face of the text itself, as well as in the practice of states and of the UN. Second, and relatedly, the obligations apply in times of armed conflict and do not allow for any derogation. Namibia accepts the right of every state to take certain measures in the interest of its national security. But those measures must be lawful and exercised in a manner consistent with recognized norms of international law. In short, a state's subjective assessment of its national security, considerations of military expediency, or alleged wrongdoing by UNRWA cannot justify the infringement of UN's privileges and immunities. Mr. President, I thank you for your attention and respectfully ask that you invite Ms. Pickering to address the court.
I thank Professor Kwa for her presentation. I now give the floor to Ms. Gladys Pickering. You have the floor, madam.
Mr. President, members of the court, it is my distinct honor to appear before you on behalf of the Republic of Namibia. I begin with the question, who is international law for? Israel argues that these proceedings, I quote, turn international law on its head in assuming that Israel has only obligations and no rights. To Israel, international law serves to safeguard the sovereignty and security of states. It prescribes the right and obligation of a state in acting to defend its existence, its territory, and its people. However, Namibia submits that Israel presents only a partial picture and one that is inconsistent with this court's jurisprudence. International law protects the rights of not only of states, but also of peoples, in particular their right to self-determination. Namibia's submission focuses on two specific obligations flowing from the right to self-determination. First, Israel has an obligation not to impede in any way the right of the Palestinian people to pursue their economic, social, and cultural development. As the court set out in the advisory opinion of July last year, this is one of the 4 key elements of the right to self-determination. It is supplemented by Israel's obligations as an occupying power under international humanitarian law, as well as under international human rights law. In this respect, UNRWA provides the Palestinian people with indispensable support to enable their development. As reported by the Secretary General, UNRWA ordinarily provides education to over 350,000 students and conducts over 5 million health consultations annually. In Gaza, UNRWA has been providing essential humanitarian assistance to the civilian population since October 2023. Without UNRWA, the Palestinian people would be deprived of their means of subsistence and their ability to pursue economic, social, and cultural development. For this reason, Israel's expulsion of UNRWA and imposition of measures to frustrate its work in the provision of education, healthcare, and emergency assistance violates the right to self-determination. Moreover, and particularly in the context of its prolonged occupation, Israel is required to facilitate by positive measures the realization of this right. This, Israel has repeatedly and systematically failed to do. Second, the Palestinian people are entitled to pursue their development as a people independently, as well as in conjunction with the UN, other international organizations, and third states. Namibia emphasizes that Israel has no legal basis to prevent international actors from operating in the OPT in the realization of the right of the Palestinian people to self-determination. In this respect, it is up to the Palestinian people to decide what forms of assistance to accept, by whom it is provided, and on what terms. In the advisory opinion of July last year, the court determined that Israel's practices constitute a systematic and prolonged violation of the Palestinian people's right to self-determination. The present proceedings concern significant further violations of that right. Israel's obstruction of the activities of the UN, particularly UNRWA, other international organizations, and third states, is part of a strategy to entrench its unlawful occupation and to further annex the Palestinian territory. It is part of a strategy to fragment the Palestinian people and to frustrate their right of return to their homeland. It is, in short, a strategy to perpetually deny their right to self-determination. Mr. President, members of the court, Namibia's final substantive submission concerns Israel's obligations under international humanitarian law and the law of occupation in relation to the provision of aid and assistance. At the outset, Namibia emphasizes that these obligations, as well as any right of Israel as an occupying power, must be interpreted in line with the right to self-determination as a peremptory norm. These obligations also complement Israel's obligations as a UN member to assist and cooperate with UNRWA. International humanitarian law and the law of occupation impose on Israel extensive obligations in relation to the provision of supplies and services to the population under occupation. These arguments are set out in full in our written statements. Here, Namibia wishes to emphasize the categorical and demanding terms of Article 59 of the Fourth Geneva Convention. If the population is inadequately supplied, the occupying power shall agree to relief schemes and facilitate them by all means at its disposal. In relation to the OPT, the situation of inadequate supply is catastrophic. The population is in critical need of supplies encompassing extremely wide-ranging forms of assistance, including food, water, electricity, fuel, shelter, clothing, hygiene and sanitation requirements, as well as medical supplies. Therefore, the demands of Article 59 are triggered. Israel is required to permit, facilitate, and protect the provision of aid and assistance by the United Nations, and particularly by UNRWA. By targeting UNRWA through anti-UNRWA laws, military operations, and related conduct, Israel is in breach of its obligations under the Geneva Conventions. In this regard, it appears that Israel's strategy is to acknowledge the existence of Article 59, but to hollow out its demands and effects in practice. Israel has done this by arguing that replacing UNRWA with other relief schemes, I quote, is not at all impossible, and by seeking to justify blanket measures against UNRWA on the ground of its alleged lack of neutrality. Namibia urges the court to reject this strategy. The first claim that UNRWA's essential services can simply be replaced is false. UNRWA is the backbone of the international community's humanitarian response in Gaza and remains responsible for the ongoing provision of critical humanitarian aid across the OPT. In reality, prohibiting UNRWA's operations with a speculative notion of possible replacement is simply a violation of Israel's obligations under humanitarian law. In this respect, Namibia urges the court to adopt an interpretation and application of the law of occupation that is sensitive to the realities on the ground. With regard to Israel's second claim and allegations challenging UNRWA's neutrality, the UN has credibly and promptly responded to the allegations. In any event, these allegations cannot possibly justify such an unreasonable and disproportionate response. Namibia reiterates that the obstruction of UNRWA's operations has directly exacerbated the humanitarian crisis in the OPT. As the primary provider of humanitarian aid in Gaza, UNRWA's absence has created a critical vacuum in the provision of aid and essential services. The current situation on the ground is the inevitable disastrous outcome of a people denied access to aid and essential services, in violation of international humanitarian law and the UN Charter. In sum, it follows from UNRWA's ongoing indispensable role that the law of occupation requires Israel to permit, facilitate, and protect the delivery of humanitarian assistance by UNRWA. In conclusion, Mr. President, Namibia reiterates that Israel is bound under international law to permit, facilitate, and protect humanitarian assistance in the occupied Palestinian territory. Israel's measures targeting UNRWA, including anti-UNRWA laws and operational restrictions, are incompatible with these obligations. Namibia regrets that the recent ceasefire did not lead to meaningful relief or protection for civilians. and reiterates its opposition to any proposal suggesting further violation of the right to self-determination of the Palestinian people in their own territory. Namibia calls upon the international community to uphold international law and to support the people of Palestine in rebuilding the Gaza Strip and restoring access to essential humanitarian aid. Namibia reiterates the necessity of accountability for violations of international law and the paramount importance of the protection of civilians. Finally, Namibia emphasizes the wider importance of the court's answer for situations of occupation in general. Mr. President, members of the court, I thank you for your kind attention. This concludes Namibia's oral submissions. Thank you.
I thank the representatives of Namibia for their presentation. I now invite the next participating delegation, Norway, to address the court. And I call upon His Excellency, Mr. Rolf Einar Fife, to take the floor.
Mr. President, distinguished members of the court, it is an honor for me to appear before this court in this case on behalf of the Kingdom of Norway. Our oral intervention will consist of 3 parts. I will address certain elements of the specific legal framework applicable to the occupied Palestinian territory. In combination, these give rise with binding force to obligations of Israel in the precise subject matter under current consideration. Director General Christian Järvel will thereafter highlight essential obligations. Finally, State Secretary Andreas Motzel-Kravik will set out Norway's submissions as to the suggested conclusions to be drawn in a context that fully justifies the court's decision to treat the request of the General Assembly with urgency and on a priority basis. Mr. President, distinguished members of the court, seldom has an international presence in a territory, and I should add, rarely have the related obligations of key protagonists been more formally and structurally embedded in a multilateral legal framework than in the occupied Palestinian territory. 3 salient facts may both illustrate this and help us structure our understanding of the specific legal framework. Firstly, when the military occupation started in June 1967, after the Six-Day War, there was an already legally established and significant international presence to support vital needs of displaced local population and a recognized need for a major international effort to protect and assist vulnerable Palestinian refugees. Secondly, the UN has a particular long-standing responsibility originating in the mandate and the 1947 petition resolution concerning Palestine. The indisputable right of self-determination of the Palestinian people and the need to devote key efforts to achieve a 2-state solution were early ascertained. Thirdly, since 1948, the realization of key objectives enshrined in a series of mandates and decisions adopted by the main organs of the UN has required international assistance consisting of a composite of assisting actors. These include competent international organizations, states, and relevant non-governmental organizations and entities, with the UN playing not only a central, but also an essential role. It provides necessary relief, support, and basic services to the civilian population. It also serves as a facilitator, organizer, and catalyst for contributions by other third parties. Heads of UN agencies and key relief providers have issued statements as to the indispensability, even the backbone role of UNRWA in this context. All of this is amply documented Nevertheless, we would be remiss if I did not mention here the appeal made already in 1948 by the UN mediator on Palestine, Count Volker Bernadotte, referring, and I quote, to the desperate urgency, unquote, of the situation. He called for a broad mobilization of relief efforts by the UN and the international community at large. UN organs, specialized agencies, states, and non-governmental actors rose to this appeal. Their swift response and the subsequent creation of UN coordinating bodies and executive agencies confirmed the scale and magnitude of the humanitarian relief and reintegration challenges. They also confirm, which is of relevance here, the breadth of necessary assisting actors and voluntary contributions by third parties. Returning now to the first point, the duty to respect the described pre-existing international presence and activities, well, that appears to have been recognized by Israel in June 1967. Fundamental rules of laws of occupation, notably enshrined in Article 43 of the Hague Regulation of 1907, require respect for the law in force in the occupied territory unless absolutely prevented from doing so, and the duty to administer the territory for the benefit of the local population. Within 4 days of the ceasefire, the so-called Comey Mission More exchange of letters thus confirmed that UNRWA would, I quote, continue, unquote, its assistance to eligible refugees with, and I quote, the full cooperation, unquote, of Israeli authorities. This ensured practical and operational continuity, including respect for pre-existing arrangements and relevant immunities of the UN. Moreover, the juridical status and privileges and immunities of subsidiary bodies of the UN do not draw their original strength or legal basis from such an exchange of letters. Israel's obligations in this regard follow with respect to UN member states from Article 105, paragraph 1 of the Charter, and they are further detailed in the 1946 Convention on the Privileges and Immunities of the UN. These obligations apply as much in Israel's sovereign territory as in the territory of Palestine. Turning now to the second point, the context and the legal framework applicable to the occupied Palestinian territory entail a particular and long-standing responsibility of the UN. This has already been noted by the court in its advisory opinion on the wall and in its advisory opinion of July last year. And this was already reflected in commitments made to cooperate with the UN in Israel's declaration of independence of 14th of May 1948. Israel's application for membership in the UN specifically stated that independence had been proclaimed, and I quote, in pursuance of, unquote, the 1947 petition resolution. It added that Israel unreservedly accepts the obligations of the United Nations Charter and undertakes to honor them from the day when it becomes a member of the UN. In May 1949, the General Assembly Resolution 273 Roman III on admission to membership explicitly referred to Israel's assurances made, and I quote, in respect of the implementation of the said resolutions, unquote. After the vote, the Israeli foreign minister stated that the aftermath of the 1948 war had changed some elements in the pattern envisaged in the 1947 petition resolution, and that, and I quote, modifications, unquote, were therefore called for. However, these did not vacate the continued relevance of the framework, and he noted that Israel's organic connection with the United Nations has combined with its compelling interest in dictating its course of action in international affairs, a course of undivided loyalty to the Charter of the United Nations and of consecration of the cause of peace, unquote. In our written statement, we have detailed how the specific legal framework applicable to the territory sets out clear obligations for Israel, not only under international humanitarian law, including as regards humanitarian relief schemes under Article 59 of the Fourth Geneva Convention, but also under human rights law, refugee law, and United Nations law. They combine in requiring duties of cooperation, facilitation, assistance, and protection for the international presence to continue the activities mentioned. My brief overview here serves as an invitation to consider more in detail the analysis made in our written statement. As to the third point, the mandates of UN agencies and specialized agencies have indeed not been static, as documented in an overwhelming number of reports, resolutions, and agreements provided by the UN Secretariat. The relevant mandates have regularly been not only adopted, but also adapted to evolving demands and circumstances. Their international legality is unequivocal. In a broader sense, we're here reminded that international law took a series of decisive legal turns with the creation of the UN, the emergence of new functions of international organizations, and the protection of human dignity and fundamental rights. Moreover, in the context just described, a legal framework was established. Nevertheless, the underpinning, or one might perhaps more accurately say a linchpin of our international legal order, rests on legal obligations incurred by states in this regard, built brick by brick over decades. It depends on their compliance, whether the obligation derives from the UN Charter, other international legal instruments, or rules determined on the basis of other valid sources of international law. In the formulation of the requested legal guidance, Norway would suggest also taking into account work carried out by the International Law Commission as regards the protection of persons in the event of disasters. Its state-of-the-art definition in 2016 of possible assisting actors may reflect the breadth of scope of relevant categories of institutions already engaged in relief and support. The Commission's references to the importance of transit are relevant also in this context. It is moreover suggested to take fully into account the legal obligations related to self-determination. Further detail will now be provided by Director General Järvel, and I would respectfully request the President to now give him the floor. And I thank you for your attention.
I thank Mr. Fife. I now give the floor to Mr. Christian Järvel. You have the floor, sir.
Mr. President, distinguished members of the Court, it's an honor for me to appear before you on behalf of the Kingdom of Norway. The request put to the Court makes specific reference to the Palestinian people's right to self-determination. As was observed by the Court in the July 2024 advisory opinion, Israel, as the occupying power of the occupied Palestinian territory, has an obligation not to impede the Palestinian people from exercising its right to self-determination, including its right to an independent and sovereign state. The Court specifically referred to the obligation to preserve the territorial integrity of the occupied Palestinian territory, to refrain from measures aimed at dispersing the population and undermining its integrity as a people, to respect the right to exercise permanent sovereignty over natural resources, and the right of the Palestinian people to freely determine its political status and to pursue its economic, social, and cultural development. Norway supports the Court's interpretation on these issues as applied to the specific factual context. In the context of the present case, it is pertinent to build on those observations and assess what implications that flow from them with regard to the question of obligations concerning international presence in and in relation to the occupied territories. I will make 2 points. First, there is an interlinkage between the obligations referred to by Ambassador FIFA and the obligation not to impede the right of the Palestinian people to self-determination. Hindering the presence and activities of the UN, international organizations and third states, and thereby the provision of development assistance and humanitarian relief to the local population constitutes a significant impediment to the Palestinian people's exercise of its right to self-determination. This is so in the perspective of Norway because such acts and measures undermine the integrity of the population as a people, and because they obstruct the right of the Palestinian people to freely determine its political status and to pursue its economic, social, and cultural development. For similar reasons, acts and measures that obstruct the provision of development assistance and humanitarian relief to the Palestinian people by the UN and its subsidiary organs constitute separate violations of obligations owed by Israel to the UN, and also constitute a significant impediment to the Palestinian people's exercise of its right to self-determination. Second, the obligation incumbent on Israel not to impede the right of the Palestinian people to self-determination also entails negative obligations. Israel must refrain from impairing the ability of the representative authorities of the Palestinian Authority or the State of Palestine to establish, conduct, and maintain foreign relations with other international actors, including the United Nations and its specialized agencies, other international organizations, and third states, and their representation to Palestine and the Palestinian people in and in relation to the occupied Palestinian territory. In this regard, the court observed in its July 2024 advisory opinion that the right of the Palestinian people to self-determination includes the right to an independent and sovereign state over the entirety of the occupied Palestinian territory, as well as the right of the Palestinian people to freely determine its political status and to pursue its economic, social, and cultural development. It follows from these observations that the Palestinian people has a right to establish and conduct foreign relations, which is part and parcel of the Palestinians' exercise of their right to freely determine their political future. Israel has a corresponding obligation to respect this right. The conduct of foreign relations constitutes a key element to promote peace and security and develop the welfare of the people concerned. It is a precondition for a successful institution and state-building process and integration into the international community. Regard may be had in this respect to the fact that the attributes normally attached to statehood in international law are generally perceived to include not only a population, a territory, and a government, but also the capacity to enter into relations with the international community on an independent basis. Where international relations are established, or sought to be established, based on and in accordance with the free will of the recognized representatives of the Palestinian people, intentional impairment of such relations would, in the view of Norway, constitute a policy and practice that obstruct the right of the Palestinian people freely to determine its political status and to pursue its economic, social, and cultural development. As such, those measures would constitute a violation of the obligation to respect the right of the Palestinian people to self-determination. The same applies to intentional impairment of the possibility for diplomatic representatives to be present in the occupied Palestinian territory for the purpose of establishing and maintaining such relations. Mr. President, honorable members of the court, Norway is among the 146 of the 193 member states of the UN that have recognized the state of Palestine as an independent state and subject of international law. What is said here concerning the conduct of foreign relations is, however, valid regardless of whether the relations in question are based on a recognition of statehood or whether formal diplomatic relations have been established. This is so because the right to communicate and carry out foreign relations with the international community forms an integral part of the right of the Palestinian people freely to determine its political status and to pursue its economic, social, and cultural development. As regards foreign relations with international organizations, there's a long pedigree of practical evidence to that effect. There is also ample evidence of agreements having been concluded in this regard between the representatives of the Palestinian people and international organizations. As regards the United Nations, reference by way of illustration is here made to the exchange of letters concluded in 1994 between UNRWA and the chairman of the Palestine Liberation Organization for the purpose of facilitating UNRWA to continue to provide assistance to the Palestinian population in the Gaza Strip and the Jericho area and in the remainder of the West Bank. Mr. President, honorable members of the court, I thank you for your attention and now ask you to give the floor to Mr. Andreas Kravik, State Secretary of the Norwegian Ministry of Foreign Affairs, to present the final observations on behalf of Norway.
I thank Mr. Yavel. I now give the floor to Mr. Andreas Mossfeldt Kravik. You have the floor.
Mr. President, honorable members of the court, it's an honor to stand before you as a representative of Norway. We meet at a time when the humanitarian situation in the occupied Palestinian territory has descended further into a living nightmare. In Gaza, a blockade of humanitarian aid and commercial supplies has been in place now for 60 days. And despite repeated calls on Israel to lift these measures and to facilitate relief, Israel has instead further tightened rather than eased these measures. This is both unconscionable and illegal. It is in this context, Norway asked the court to recognize the indispensable nature of UNRWA in running infrastructure, healthcare, education, primary assistance, and in providing relief to Palestinian refugees. Mr. President, honorable members of the court, Norway has consistently condemned the heinous attacks directed at Israel on 7th of October 2023. We have called for an immediate ceasefire, and we have called also for the immediate and unconditional release of all hostages. With the same consistency, however, Norway has also held that Israel, like any other UN member state, must abide by its legal obligations. Against this backdrop, I will make 3 points. First, Israel's obligations to cooperate with the United Nations and with other states. Second, the Palestinian people's right under the principle of self-determination to decide freely as to its external relations. And third and finally, Israel's obligation to permit and facilitate assistance, including to facilitate the unimpeded transit of UNRWA and other UN personnel. Turning now to my first point. Israel has an obligation to cooperate with the United Nations as set forth in Article 2, Paragraph 5 of the Charter. This is a general obligation, not limited to enforcement action by the Security Council. In the present context, this means, as the Secretary General rightly has observed, and I quote, that Israel is obliged to give UNRWA every assistance in any action it takes in accordance with the relevant decisions of competent organs adopted pursuant to the provisions of the Charter, end quote. Israel's duty to cooperate with other states in solving international problems of a humanitarian character in the occupied Palestinian territory is laid down in Article 1, Paragraph 3 of the Charter. That provision is, as evident from Article 14 of the Charter, legally binding on states. And the obligation in Article 1, Paragraph 3 is further developed in the Friendly Relations Declaration. It is possible, as Professor Von Loh has observed, and I quote, to establish a legal duty to cooperate in specific legal contexts and to measure a state's compliance with it. Norway submits that Israel has, in the specific context of the humanitarian disaster it has created in the occupied Palestinian territory, an obligation to cooperate with other states in facilitating the provision of humanitarian development assistance where such is offered. To conclude on this first point, Israel has obligations under the Charter to take all necessary and effective measures to ensure, without delay, in full collaboration with the United Nations and third states, the unhindered provisions at scale of urgently needed basic services and humanitarian assistance. This can be achieved only by lifting the blockade, dramatically increasing the number and capacity of land crossing points, and keeping them open. Secondly, Israel has an obligation to respect the establishment and conduct of foreign relations by the representatives of Palestinian people with international organizations and third states. This includes the obligation not to impede the right of Palestine and its people to decide freely as to its external relations, and, relatedly, the obligation for Israel not to impede Palestine's conduct of its foreign relations, notably Palestine's relations with the United Nations, including UNRWA, other international organizations and third states, and their representation to Palestine and its people in and in relation to the occupied Palestinian territory. Third and finally, Israel has an obligation to permit and facilitate assistance, including free passage in transit through Israel of necessary civilian supplies, personnel and equipment from the United Nations, other international organizations, and third states. Notable in this regard is the codification of customary international law, represented especially by Articles 7, 8, and 9 of the Convention on the Safety of United Nations and Associated Personnel, which was adopted by consensus by the General Assembly. The rules of customary international law codified in the Safety Convention oblige Israel to facilitate the unimpeded transit of UNRWA and other UN personnel across its territory and from one part of the occupied Palestinian territory to another. Mr. President, honorable members of the court, Norway trusts that the court, in its advisory opinion, will assist the United Nations in the furtherance of its permanent responsibility for the former mandated territory of Palestine, and that it will also assist the United Nations, other international organizations, and third states in their efforts to realize the right to self-determination for the peoples affected by the conflict, based on the vision of two states living in peace within secure and recognized borders. Mr. President, members of the court, I come to the end of Norway's oral statement. I thank you for your attention.
I thank the representatives of Norway for their presentation. This concludes this morning's sitting. The oral proceedings will resume this afternoon at 3 p.m. in order for Pakistan, Panama, Poland, Qatar, and the United Kingdom to be heard on the questions submitted to the court. The sitting is closed.